swatting, forged FBI letters, false recruitment campaigns. This is where the Marilyn Manson complaint in his lawsuit against Evan Rachel Wood and Illma Gore gets very spicy. In this video, we're going to go over probably the meatiest part of the complaint that he filed back in March against the two defendants. Let's get into it. Hey everyone, welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. So this is the next installment of going through the Marilyn Manson complaint filed against Evan Rachel Wood and Illma Gore. There is a defamation case that he has filed against the two having to do with DV claims. The reason why some people are pretty interested in this particular case is because it feels similar in some respects to the Johnny Depp versus Amber Heard defamation trial, which of course, regardless of how similar the two feel, we have to treat them differently because they are different individuals entirely that are involved in this case, potentially different facts. I mean, definitely different facts, and even a different jurisdiction. So we're in California in this particular case, whereas that other case was in Virginia. So as we are going through, keep that in mind. But we're making our way through this particular complaint. And the reason why I decided to break it down was because it's pretty wild, right? And there are a number of different causes of action that are slightly different from one another. So I wanted to give each their own treatment so that we can kind of break it down and digest it in a bit more of an easy kind of way. Can I talk? Anyway, you know what I mean. So in this particular video, we are focusing specifically on the cause of action called intentional infliction of emotional distress. I did a brief once over of this particular claim in the intro, one of the intro videos that I did already in this on this channel. However, this one is going to go a little bit deeper. So here's a quick roadmap for how this video is going to go down. First, I'm going to go through again the elements of intentional infliction of emotional distress so that you can understand what it is that Brian Warner, aka Marilyn Manson, has to prove in order to win on this particular cause of action. Second, we'll do a brief overview of the various types of conduct that he says were extreme and outrageous and gave rise to this liability of this particular claim. And third, then we'll go into more into depth into those allegations of conduct to see what exactly he says about these particular events that gave rise, that he says gave rise to this liability. Then finally, we'll go through the application of these facts to the elements of intentional infliction of emotional distress, talk about whether or not I think that they meet the elements and whether, or at the very least, whether he's stated a claim for them at this early stage. And then you give me your thoughts. Let me know what you think about this particular case, about this particular claim. Do you think that there is a possibility that he might have something there, or is he just trying to potentially silence some DV survivors that are speaking out against him, etc.? Anyway, let's get into it. So what exactly is intentional infliction of emotional distress? It's where the defendant does something that is outrageous, that causes the plaintiff extreme emotional harm. So with that, there are four basic elements that the plaintiff has to prove in order to win on a case of IIED. First is that the plaintiff has to show that the defendant engaged in extreme and outrageous conduct. Second, the plaintiff has to show that the defendant did that with the intention of causing or with reckless disregard as to the probability of causing emotional distress. Third, the plaintiff has to show that they suffered severe or extreme emotional distress afterwards. And finally, the plaintiff also has to show that that severe emotional distress was actually and proximately caused by the defendant's extreme and outrageous conduct. Now, although the plaintiff has to show all of those elements in order to win, in the earliest stage of a lawsuit where they are just filing a complaint, we call that the pleading stage. All they have to do is make the allegations. They have to make factual allegations that state that kind of a claim and that check all of those boxes for all of those elements. As we get closer to trial, they have to actually have evidence that will fit into those boxes. So the standard gets higher and higher that they have to meet in order for the lawsuit to progress. But although they have to still show all of those four elements, usually the fight comes down to two, but usually one element in particular. The second to most litigated element in this cause of action is arguably the severe emotional distress element. That's because, of course, the plaintiff has to show that they have actually suffered severe emotional distress. They can't just have been offended by something and then moved on with their life and been like, no, but you just made me angry or something. They have to have actual evidence backing up that they really, really were impacted by this. But more than that is the element of the extreme and outrageous conduct by the defendant. That is the one where usually the biggest fight happens in this particular cause of action. Now, courts have said that it's not enough for the defendant to have just been rude or insensitive or offensive, because we have a very strong protection of First Amendment speech and conduct that can be speech, for example. So there are certain protections for certain types of conduct that could be deemed offensive, as an example. For example, courts that have analyzed California's IIED laws have said that yelling and screaming in the process of criticizing the plaintiff's job performance is not enough, nor is yelling and screaming at a plaintiff for making a mistake, nor is threatening to terminate the plaintiff from her employment or making threatening gestures. None of those on their own are enough under California law to rise to the level of extreme and outrageous conduct as is necessary for that element for IIED. Rather, courts maintain that outrageous conduct is that which no reasonable person in a civilized society should be expected to endure. So it has to be, it has to be the kind of thing that people would look at and say, that is horrific. As an example, some courts analyzing California's IIED laws have said that harassing emails might constitute intentional infliction of emotional distress, and threats of harm or death to the plaintiff and his family for failure to sign a new union agreement are sufficiently outrageous. So sometimes you can have some courts that fall on one side of a gray line or on another side of a gray line, but generally speaking, you can kind of start to see where the outrageous line basically is. Now, one thing to note is that a court can consider evidence of a particular personal relationship between the plaintiff and the defendant to provide evidence for a particular vulnerability or susceptibility to emotional distress that the plaintiff would have known about because of that specific relationship. And that can basically play into it as well. Anyway, let's get into the particular type of conduct that Brian Warner alleges is extreme and outrageous in this particular case. Okay, so here we have the first cause of action, which is the IIED cause of action. Now, one thing to note is that usually when you're drafting a complaint, you do want your strongest one to be listed first. It just is one of the best practices for drafting these kinds of things, generally speaking. Okay, first off, what we're looking for is whether or not he alleges enough to sufficiently check those boxes that we went over that were the elements of IIED. We won't do it one for one in this part. We'll do it in the application part of this video, but keep that in mind as we go through. Okay, the first cause of action, intentional infliction of emotional distress. Paragraph 62, Warner incorporates by reference the preceding allegations as if fully set forth herein. That is always the first paragraph under any cause of action. It just incorporates everything in just to make sure that anything that you've alleged before can be sort of woven together here. Moving on though. Gore's and Wood's conduct was outrageous in that it was extreme, so extreme as to exceed all bounds of that usually tolerated in a civilized community. This conduct included, so we're getting into the extreme and outrageous allegation here. A, initiating at least one incident of illegal and highly dangerous swatting of Warner in February 2021. B, soliciting, receiving, and using logins and passwords for Warner's personal and business social media and email accounts and his address, phone number, and social security number without his permission. C, falsifying correspondence from a fictitious federal agent claiming that there was concern for the safety of Wood, other alleged victims of Warner and their families, as well as an ongoing federal criminal investigation targeting Warner. D, making knowingly false and defamatory statements against Warner, including that the actress in the groupie video was a minor and that Warner was manufacturing illicit material of minors. And E, recruiting, coordinating, and pressuring multiple women to make false accusations against Warner and to be part of their film project. So that part D we went over in the last video under the defamation per se allegations. So we are not going to actually go into those in-depth allegations since we already did. We don't need to do it again. Paragraph 64 says Gore and Wood intended to cause Warner emotional distress. In the alternative, Gore and Wood acted with reckless disregard of the probability that Warner would suffer emotional distress as a result of their conduct. Warner suffered severe emotional distress. Then it goes on to say Gore's and Wood's outrageous conduct was a substantial factor in causing Warner's severe emotional distress and was the actual and proximate cause of the emotional distress. Finally, Gore and Wood acted with oppression, fraud, or malice as defined by California Civil Code Section 3294 and engaged in highly reprehensible conduct warranting punitive damages. So he's going for punies. Okay, so now let's go into the more detailed factual allegations to support his allegations of the extreme and outrageous conduct, according to Brian Warner. Aside from, of course, like I mentioned, Part D, since we already went over that in a previous video. If you haven't already seen that, be sure to check that out. Okay, so I'm going to go through this not in the order that he alleges it in the factual allegation section. I'm going to go through it in the order in which he listed it under the IIED cause of action. So even though he talks about some of these before he talks about swatting, because he listed swatted first under IIED, I'm going to do that first. So Section D, Gore swats Warner in February 2021. He says that swatting is the harassment tactic of making a hoax or prank report to emergency services to elicit the dispatch of a large number of armed police officers, e.g. the Special Weapons and Tactics Unit or Tactics SWAT team, to a particular location or address. Swatting is often triggered by the false report of a serious law enforcement emergency, such as a bomb threat, homicide, hostage situation, or a mental health emergency, for example. The claim that an individual at a certain location is suicidal, homicidal, or unwell. And then he has a lot of citations to that. He's got a footnote down at the bottom with a lot of different resources. Swatting creates fear, anxiety, and trauma in its victims, as it did with Warner. It spurs copycats, especially where the victims are celebrities or where the incidents are publicized. And of course, it carries a high risk of violence, not only for the innocent victims of swatting, but also for the law enforcement officers responding to what then appears to be a serious emergency. Accordingly, swatting is and has been a crime in California under Penal Code Section 148.3, as well as in other states and under federal law. So he goes on to say, Gore swatted Warner on or around February 3rd, 2021. The LAPD was notified that the FBI received a call from a friend, quote-unquote friend, of Warner named Illma Gore, who claimed that an emergency existed because she had not been able to reach him and was concerned for his safety. This report was false. Warner was at home with his wife and a guest and not in any danger. Gore knew her report was false. She and Warner have never even met. She has never been Warner's quote-unquote friend and had no basis to believe Warner posed any risk of danger to himself. On the evening of February 3rd, 2021, multiple LAPD officers and squad cars responded to the purported emergency at Warner's home. When Warner did not answer the door, more units arrived and an LAPD helicopter was deployed. The officers continued to attempt to gain access into Warner's home, and the low-flying helicopter circled above, shining its spotlight onto Warner's property and into the windows of his home. At approximately 8:10 p.m., a person associated with Warner received an email from an LAPD detective stating that today we were notified by the FBI that they had received a call from a friend of Mr. Manson. The friend, Illma Gore, was not been able to reach him and is concerned for his safety. We went to his residence, but there was no answer. Is there a way for us to contact him to check on his well-being? If not, can you have him reach out to Illma? The LAPD returned multiple times and entered Warner's property. Eventually, the police left after determining that there was no evidence of any trouble. In addition to 4 LAPD squad cars and a helicopter, paparazzi were at Warner's doorstep. When the police arrived, the paparazzi took videos and photographs and recorded someone making the false statements, which can be heard in the videos, that a person inside the house was screaming for help. This created an even more dangerous situation for Warner and his wife and guest inside the house. Upon information and belief, the paparazzi were present because they had been tipped off in advance by Gore, who, as explained below, had solicited and improperly received Warner's home address and other personal information. That evening, video and images of the police response were posted and went viral online as it was reported that, quote, Marilyn Manson's home was swarming with cops after a worried friend called concerned for the singer's well-being, saying they'd been unable to get in touch with him for hours, unquote. Other outlets reported that, quote, welfare check was requested by an alarmed friend who had spent several hours trying to contact the singer just days after a slew of women publicly accused him of abuse, quote unquote. Many of these published stories linked the abuse allegations made against Warner to the police response. Predictably, press reports focused heavily on the fact that just 2 days earlier, on February 1st, 2021, Wood and several other women made public accusations against Warner. This was all by design. Gore made the false report in order to elicit the dispatch of a large number of armed police officers to Warner's home. Gore's purposes included harassing and causing harm to Warner in the immediate wake of the highly organized and orchestrated February 1st, 2021 accusations, drawing further attention to the false allegations against Warner that she had coordinated and creating a situation that could result in video footage of Warner being arrested. It also created a scenario in which Warner, his wife, or his guest could have been harmed in the chaos of the moment. This swatting by Gore was part of a scheme to benefit the Phoenix Act, Wood and the film project, and to curry favor with Wood and potential and existing accusers against Warner. Based on the press coverage of the police response, which reported on the disturbing incident, quote unquote, at Warner's home and the allegations levied days earlier, but not that this quote unquote welfare check was a hoax, Gore was successful. So that's the swatting allegations. Basically, it comes down to a fraudulent welfare check. Let's continue. Next up, he points to the allegation about the personal and business, social media, and email accounts. So there are two sections having to do with email and social media, so we'll go through both of those. First is section C of the Factual Allegations, titled, Gore Creates a Fictitious Email Account Impersonating Warner. And here it says, from in or around September 2019 until the present, Gore used fake email accounts pretending to be Warner to create correspondence that she believed would be harmful to Warner and bolster the allegations levied against him. One such fake email account created and controlled by Gore was bhwarner1969@gmail.com. BHW, Warner's initials in 1969, is the year he was born. Warner did not create this email account and never used it. For example, upon information and belief, in or around September 2019, Gore used these fake accounts to send and received emails containing links to illicit material. Upon information and belief, these links are believed to have contained prohibited content, as the URLs currently do not work and thus were likely taken down. As another example, upon information and belief, Gore used fake email accounts to create documents that looked like Warner communicating with attorneys regarding a criminal investigation. In one such email dated February 8th, 2021, just days after Wood and several others made fictitious claims of abuse against Warner in a coordinated attack, BH Warner 1969 received an email from a person purporting to be writing on behalf of Warner's attorney. However, the email's purported sender did not work for or ever work for that attorney. Upon information and belief, Gore created these documents as part of the wrongful conspiracy against Warner to enhance her reputation and esteem with Wood, the Phoenix Act, and persons that she was soliciting or has solicited to speak out against Warner, and ultimately to enrich herself. Warner first learned of these fake email accounts and the fake emails described above in November 2021, when copies of these emails were shared with him. Before that, Warner had never received any email sent to him to or from these fake email accounts. Accordingly, Warner did not discover, and a reasonable and diligent investigation would not have disclosed, that Gore's use of fake email accounts contributed to Warner's harm. Okay, so let's go to that other section having to do with emails and social media. Now that would be section E, titled Gore Hacks Warner's Computer Files and Social Media Accounts. Paragraph 51 says, upon information and belief, Gore gained unauthorized access to, e.g. hacked, Warner's email login and passwords, social media login and passwords, and social security number. Among other sources, Gore solicited and obtained this information from Ashley Walters. Walters was Warner's former assistant and one of the women recruited by Gore and Wood to make accusations against Warner. As part of her work for Warner, Walters was entrusted with Warner's private information by Warner and his representatives. As is common in the entertainment business and numerous other professions that handle sensitive, potentially high-profile matters, Walters entered into a confidentiality agreement that prohibited her from disclosing such information. Gore procured from Walters, among other private and protected information, Warner's email and social media logins and passwords, and Warner's social security number, home address, and phone number. Gore procured this information knowing that she would use it to gain access to and use data, a computer system, a computer network, and or computer services. One of the things that pops out to me, however, is the fact that he's alleging that she also got his home address, and phone number. I don't know if he moved since his relationship with Evan Rachel Wood concluded, or if he had changed his phone number since then. But it would seem that Evan Rachel Wood would have access to that information just from the course of their relationship as well. So I'm curious to see how that works in. But that's just one portion. I mean, it's not necessarily a given that someone that you're in a relationship with, even engaged to, would have access to your social media passwords, your email passwords, and that kind of stuff. It's not necessarily always the case that a couple in a romantic relationship is going to share that kind of information. And also another note is that they pointed to the fact that Ashley Walters was operating under a confidentiality agreement. So the confidentiality agreement would be, that is a contract, right? So Walters would potentially be in breach of a contract, in which case he would have a claim against her, but I don't know if the statute of limitations had run since the time that he had discovered that potential breach, or if he was even interested in filing a claim against her for that on that basis. But that's also an interesting twist to note as well. Anyway, moving on. So paragraph 54 continues. Indeed, Gore has a history with precisely this type of wrongful conduct. In November 2021, a Santa Cruz County judge issued a temporary restraining order against Gore after her twin sister recounted that Gore committed digital spying and stalking against me, made me fear that I and my children were in immediate danger and serious physical injury, and disturbed my peace, liberty, and free will with coercive control. Gore has boasted that she has a computer science background and is interested in hacking. Upon information and belief, Gore used information provided by Walters and others to gain access to Warner's personal details, private conversations, email accounts, phones, and social media accounts. Gore used the information she obtained as part of her scheme to orchestrate and promulgate false accusations against Warner, including the coordinated false accusations against Warner on February 1st, 2021 and thereafter, which would bring further attention to the Phoenix Act, Wood, and the film project, and to curry favor with Wood and potential and existing accusers against Warner. Okay, so that is the social media and email hacking and impersonating portion. Now let's look at the fake FBI letter factual allegations in detail. Section B of the factual allegations portion of the complaint is titled, Wood and Gore impersonate an actual FBI agent by forging a fictitious letter claiming that Wood and other alleged victims of Warner were in danger. Paragraph 32 starts out, Wood and Gore conspired to impersonate a federal agent by creating and distributing a fictitious letter attached hereto as Attachment A. The letter, which Wood and Gore attributed to a real-life federal agent and included a forged signature and fake phone number for that agent, stated that there was an ongoing law enforcement investigation into Warner and there was concern for the safety of Wood, other quote-unquote victims of Warner, and their families. The federal agent whose name and alleged signature appear on the letter has confirmed that she did not author that letter, had no knowledge of the letter, did not authorize or approve the letter, and has never been involved in any criminal investigation of Warner. The purported federal agency that the letter associates with the agent, the Federal Violent Crimes Division, does not even appear to exist. Okay. Screenshots of a conversation between Gore and Wood show that the text of the letter was drafted by Wood and Gore, not the FBI agent. Wood drafted the text of the letter and asked for and received feedback from Gore, including to remove a reference to an imminent arrest. In the conversation copied below, quote-unquote Alabama is Wood, a nickname she was given around the time of her relationship with Warner. And here is a screenshot of a text message. It looks like it's between Alabama and someone else. So on the left side, we have text bubbles in gray. On the right side, we have text bubbles in blue. So first it says in gray, whoa, I never seen this one. And this is dated November 21st at 6:41 p.m. Then November 21st at 9:08 p.m. is a response, blank is my new number, and it's been redacted. Is my new number. Then on November 22nd at 8:17 p.m., it says, here is the letter. To whom it may concern, please be advised that Miss Evan Rachel Wood is one of the primary witnesses in connection with an impending criminal prosecution in Los Angeles involving an international and well-known public figure. We have advised Miss Wood that in our opinion, it is in her and her family's best interest to not be in Los Angeles at the time of the individual's arrest and the criminal proceedings. The safety of Miss Wood, her son Jack, as well as the other victims and their families are of our utmost concern during this time. What you think? And then in text bubbles in blue, responding saying it's good. I don't know about the letter stating the arrest before it happens. So about this text screenshot, it seems that it's being offered as a conversation between Evan Rachel Wood and Illma Gore. My big question is how they came across this. Who would have had access? Because either the conversations between those two, one of them would have had to have given some kind of access to their phones or their cloud in order for this to somehow end up in the hands of Brian Warner. And I have some questions as to how they got this and how this is going to be authenticated. This can be authenticated, of course, with metadata. If you followed the Johnny Depp versus Amber Heard trial, metadata was a big issue there. Metadata can be a big issue in a lot of cases these days that have to do with screenshots and photos taken from iPhones or from Androids or what have you. But I have some questions, and it's not to say that I'm skeptical of the existence of this conversation. It's very interesting, and it would be very damning if this actually has the metadata to back it up. Okay, moving on. Paragraph 36 states, in addition to the crimes detailed above, Wood submitted the forged letter in a California custody proceeding, using it as supposed evidence for why she should be able to move her son to Tennessee. Citing and quoting from the letter, Wood lied under penalty of perjury, stating that she was advised by criminal investigators that my and my family's safety was at risk, and that to punctuate the seriousness of the situation, I was provided with a correspondence from a representative of the Federal Violent Crimes Department from the FBI. So one problem with this is that if this was only used for the purposes of litigation, for example, child custody, it says here, this is what's being alleged in the complaint. My concern for Marilyn Manson's side here is that this looks like it would be covered by the litigation privilege. If something was introduced, even if it was a forged document, but it was introduced in litigation, California law is pretty expansive about the litigation privilege. So if this was only used, like I said, only used in litigation, my thought is that this probably can't be used for purposes of defamation or intentional infliction of emotional distress, because that is a defense also to IIED. Now, if it was used elsewhere, that's a different story, because just because you've made a defamatory statement or you have conducted yourself in a particular what have you, litigation proceeding, you've engaged in certain conduct that is extreme and outrageous, that would be protected by the privilege, by the litigation privilege, doesn't necessarily mean that it shields you from doing the same thing elsewhere. So you can't just like do it in a litigation proceeding and then do it everywhere else, and then you're protected everywhere else. It doesn't work that way. So let's continue reading and see if there's more to it. Paragraph 37 says, upon information and belief, Gore aided and abetted Wood in forging the letter because the letter would help Wood. The forged letter would be picked up by the press and draw attention to the Phoenix Act, Wood, and the false allegations against Warner. And the forged letter would be used to recruit, encourage, and convince people to claim they were abused by Warner because they were being led to believe that Warner was a threat to their safety and under federal investigation. So, okay, there is potentially more here because there's more that's been alleged about. I don't know about the part about it being picked up by the press. If I were their attorney, I would have rather phrased that as they sent it to the press, because that is much more active conduct as opposed to passive language. However, they also said that the forged letter would be used to recruit, encourage, and convince people to claim they were abused by Warner. That is in context with the other allegations in the complaint about this whole recruitment strategy. He does allege very active verbiage there for that particular allegation. So in context, I think that this shows that the letter was used in multiple ways, not just in litigation, in which case that could potentially overcome that litigation privilege. Okay, so the next allegation under the IIED section was the conduct about the groupie video. We already talked about that in the defamation video, so I won't go over that again. Finally, we're going to go into the allegation of Evan Rachel Wood's and Illma Gore's alleged recruitment and coordination and pressuring of women to make false accusations against Brian Warner. And now this is section A of the factual allegations section, titled Wood and Gore recruit, coordinate, and pressure prospective accusers to make false accusations against Warner. Paragraph 25 starts off saying Gore used the Phoenix Act in connection with film project to recruit, coordinate, and pressure women who had been linked to Warner to make false accusations of abuse against him. Gore did this with Wood's assistance and or acquiescence. Together, Wood and Gore coordinated allegations and devised the specific buzzwords, phrases, and talking points that prospective accusers would use when they gave interviews or posted their stories on social media, and organized meetings where prospective accusers were encouraged to align their stories and believe not only that their decade-old consensual encounters with Warner were abusive, but also, as multiple accusers have publicly stated, that the alleged abuse caused them to repress their memories for 10 or more years. Now, I'm going to be getting into this issue of memory repression versus memory realization. I know that there have been a lot of folks in the comments that have talked about memory realization where abused or where survivors, only later on realize that the encounters that they had with someone were abusive. That's one thing. Suddenly, remembering repressed memories, I think, is another issue. My plan is to reach out to some psychologists to have some discussions about those phenomena, whether or not they are real, how often people might encounter that kind of thing, and what's the likelihood of something like that happening in a case like this, as it's been described in this particular case. But otherwise, that's another video for another day. We're going to continue going through this particular section here. Paragraph 26 says Gore solicited prospective accusers by phone, text message, email, and or social media with messages such as the following. Hey, I know this is a strange way to reach out, but my name is Illma. I work with the Phoenix Act. I run it alongside Evan Rachel Wood. We were organizing a group of people to meet up in Los Angeles and Zoom/Skype in to talk about experience that they had that might be similar to yours. I'm not sure that you would be interested in participating. You aren't obligated to speak, but if you wanted to listen in, that would be fine. It's a small group and you are personally invited. If you wanted to know more first, I would be happy to jump on the phone or email more details. Best, Illma. And then there's a footnote down here at the bottom to a particular YouTube video, which I think we can probably go over at a later date, but I believe that is the link to the video by Greta Aurora, who talks about how she received a message like that. She says that she never experienced any kind of abusive situation with Brian Warner, and so she kind of was like ringing alarm bells about this particular correspondence, saying that they are trying to solicit or elicit rather false accusations against Brian Warner through a coordinated attempt. So she is a potential witness for Brian Warner for this particular issue. Very interesting, and I'm very, very interested in digging further into that and possibly talking with her if she would like. So, but otherwise, carrying on, paragraph 27 says Gore used her proximity to Wood to attract and pressure potential accusers. She bragged to them that she was close with Wood and was acting on behalf of the Phoenix Act, which she ran alongside Wood. Gore wooed potential accusers by claiming that she wanted them to organize through the Phoenix Act coalition and were personally invited to participate in small groups with Wood. The clear implication was that potential accusers could also be close to Wood, a famous actress, if they participated and agreed to be featured in Wood's film. These meetings, which provided a forum to coordinate allegations, were filmed for Phoenix Rising. Gore further enticed potential accusers to allege abuse by suggesting that she was already amassing evidence for a claimed ongoing criminal investigation of Warner and that her efforts would lead to Warner's arrest. Gore planned that in addition to filming these small group sessions with Wood and the recruited accusers, the film crew would also record Gore and or Wood dropping off their evidence, quote unquote, off to law enforcement and Warner's anticipated arrest. Gore and others working on the film with her also repeatedly referenced a claimed ongoing criminal investigation to intimidate potential accusers, including by suggesting both directly and by implication that if they did not participate, they could be in danger and security would not be provided for them and their families. Continuing on to paragraph 29, as further evidence of wrongful coordination, Gore provided prospective accusers with a list with a checklist of 21 fabricated acts of abuse to ensure that their public claims against Warner would mirror each other and create the fake perception of a pattern of wrongful conduct. A copy of that checklist is attached here to as attachment B. And in one of my earliest intro videos, I showed that attachment B as well as attachment A, which was the alleged forged FBI letter. So if you want to see those in more detail, go and check those out in that particular video. Otherwise, let's continue on here. The public allegations since made against Warner are not only strikingly similar to each other, but also nearly identical to the recruiting checklist. Wood admitted in part one of Phoenix Rising that many of these other women's allegations were almost word for word my story. No wonder why. As for their evidence of coordination upon information and belief, Gore provided and or edited scripts for one or more of the recruited accusers to read from in describing their alleged abuse by Warner in media interviews. An example of one such script is attached here too as attachment C. I also showed that in one of my earlier intro videos. In addition to prompting specific allegations with checklists, Gore, with Wood's assistance and or acquiescence, encouraged prospective accusers to fabricate, change, embellish, and exaggerate their stories, including to make up that they had been AR'd by Warner, trafficked by Warner, and were too scared to speak out. Indeed, Wood and Gore convinced prospective accusers that their failures to allege of abuse over the past 10 years was not because no abuse occurred, but instead because abuse caused people to quote unquote repress their memories. Multiple accusers have publicly admitted that until their meetings with Gore and Wood, they had quote unquote no memory of abuse. In that these meetings unlocked new memories and that they learned from the other participants in Wood's and Gore's groups things they would later accuse Warner of. Some women who Wood and Gore contacted refused to participate because what they were being asked to say was not true. To the contrary, a number of Warner's romantic partners, including some recruited by Wood and Gore, have come forward to say that the allegations did not match their experiences with him. Greta Aurora, who I mentioned before, who was recruited by Gore but refused to participate in the coordinated attack, has stated publicly that she was still depicted falsely as a victim in a lawsuit filed by Gore associate and Warner's former assistant, Ashley Walters. Okay, and so here is where there is a footnote to a Greta Aurora video. So that other YouTube video may have been by Greta Aurora, but I need to double check again. I reviewed one of them at least, so it's been a minute. But anyway, that is the factual allegations as laid out in detail in the complaint. Let's next turn to the application part to see if all of the elements of IIED are met for each of these pieces of conduct. Okay, so now applying all of the facts that have been alleged for intentional infliction of emotional distress to the elements of IIED, let's look first at the ones that can be kind of checked off from the get-go based on his general allegations. First off, element number 3, he says that he suffered severe or extreme emotional distress. Easy, check the box. He also said that that severe and extreme emotional distress was actually and proximately caused by the defendant's outrageous conduct. So right off the bat, 2 out of 4, you've got him. He also alleges in the specific IIED section that Wood and Gore had the intention of causing or were at the very least reckless as to the probability of causing him emotional distress. So 3 out of 4 right there. The part where the rubber really meets the road is in that first element. Like I said before, extreme and outrageous conduct by the defendant. So let's go through each of these examples of what he alleges are extreme and outrageous conduct to see if they are sufficiently extreme and outrageous. First off, looking at the swatting issue. So it can't just be something that's rude. It can't just be something that is offensive. It has to be something that is actually particularly outrageous. Now, this one I'm not entirely certain of, but I think that there probably is enough there to at least state a claim, right? Because we're talking about swatting, we're talking about a wellness check. Somebody could have a genuine belief that something is wrong with someone, especially if they have reason to believe that they might be in a particular emotional state a couple days following when certain allegations come out. However, the fact that there is seemingly evidence that that call was made by Illma Gore, if it had been made by Evan Rachel Wood, that would be one thing. There could be some legitimate concern by the person that used to be in a relationship with you. However, someone like Illma Gore, who he says that he's never met before, saying, this is my friend, I've been trying to reach him for hours, when none of that is actually true, is definitely suspect. So it seems like it's making essentially a fraudulent call to the police about a wellness check, knowing that that's going to cause the police to come. And the fact that the paparazzi also arrived shows that they were probably tipped off, because I'm sure that if this goes to trial, they would have somebody saying the paparazzi doesn't just show up anywhere. They don't just hang out around Marilyn Manson's house, right? There's plenty of celebrities around Hollywood for them to find juicier stuff on a regular basis. They're not just hanging around. They're usually going to where they've been tipped off. So if those factors come together, it could be sufficiently outrageous that somebody is sort of concocting this publicity stunt, so to speak, in order to draw more attention to a particular claim. So although on its face, I don't know that just, on its own, something like a wellness check, even if it's not a real wellness check, might not be enough. But the publicity, the paparazzi, all of that together, I think probably is going to be enough for a proper IIED claim. Now, going into the hacking of the email accounts and the social media accounts, and then also the emailing suspicious material, let's say illicit material, or links to illicit material, or what looks like illicit material. How many times can I say illicit material? But, that whole part, I think, also is not really something that we generally tolerate in a civilized society. It's the kind of thing that we not only don't expect, but it seems pretty dirty, pretty nefarious. And it almost seems like the suggestion is that is being set up so that it can be then hacked, and then like, oh, look, this came out about him. Look what he's doing. This is super dirty and gross and horrific. And oh, there's also material about children. And like, he's a criminal, like there's stuff like that could be particularly nefarious there. So the potential criminal aspect, I think, also helps to make that particularly outrageous. Now, whether or not that particular move was made with the intention of causing or with recklessness about it, I mean, recklessness is probably where you would get something like that, because it doesn't seem like that is something that was made publicly. It seems like the intent was to try to do that surreptitiously, and maybe they were sort of like found out in the act, and so they weren't able to possibly put a certain plan into action, or at least lead it all the way to their desired conclusion. If the allegations, of course, are correct. I'm assuming that that's correct to sort of go along with this line of thinking. But so the fact that this wasn't really a publicity stunt, unlike the whole swatting issue, the intention aspect of that element here, although he's checked the box. So for purposes of allegation, he's alleged that all of this was intentional, or at the very least reckless. But I think that when it comes to actually proving this particular matter, I think that what he would be using is probably recklessness, as opposed to having the positive intention of causing him harm by creating this whole email sort of situation. After that is the FBI letter, which, of course, setting aside the litigation privilege issue that I mentioned before, that's probably something that I could go into a bit more detail in a particular video. There's a lot that can be talked about with a lot of this stuff. But the FBI letter is also something that would, at the very least, I think you could get there with recklessness. I don't know about intention, but recklessness, I could imagine it. But forging a fake FBI letter and sending that around to prospective accusers with the intent that they come out and that they sort of serve this whole purpose of a conspiracy, I think that probably is going to be sufficiently outrageous. It's not really something that a court of law would really want to tolerate in a civilized society, or that, generally speaking, the general public, I think, would want to tolerate in a civilized society. Then we have the allegedly defamatory statements about the groupie video, which I didn't go through in detail in this video, but I did in the last video. But that one also is probably sufficiently outrageous to lie about whether an actress in a particular video was a minor when she was supposedly engaging in illicit activities with a musician for a music video or for a film, and that she was also not alive. So that those kinds of false statements also could be sufficiently outrageous. And finally, the recruitment and coordination and pressuring women to make false accusations. That kind of a conspiracy would also be, I think, sufficiently outrageous, because it's the kind of thing that is kind of shocking if true. So anyhow, my personal assessment is that these particular claims probably on their own state a cause of action for IIED. They would give rise to IIED. But whether or not they survive an anti-SLAPP motion will be the subject of another video coming up soon. So otherwise, what do you think? What do you think about this particular case? I know that there has been a lot of discussion. There's been a lot of conversations that other YouTubers have had about this particular case. They've had conversations with potential witnesses. Colonel Kurtz is one of those that has been spearheading, but there's a lot of other YouTubers that have also been talking about this case as well. My intent is also to get into more of the evidence that's out there to see where things kind of shake out, where things line up. What do other people say about these particular allegations? So if there are particular people that you would like for me to talk to in going through this particular case, let me know in the comments down below. And also, let me know whether you think that there's enough here for an IIED cause of action. Do you think that there's a possibility here that he may be correct in what he's alleging? Or do you believe Evan Rachel Wood and Illma Gore and the other accusers here? We're going to go into more of their accusations and the things that they've said as well. But as for this video, thank you so much for watching. And if you found this interesting and informative, I really hope you did. And if you did, I would love it if you would like the video. It really does help us with the YouTube algorithm gods. And if you haven't done so already, be sure to hit the subscribe button and the notification bell so you can find out when the next video is uploaded, whether it's another live stream or another video on demand, just like this one. See you in the next video.